Good morning, everybody. This is Mark Solomon. It's about 9:59 by my watch. We've got a whole bunch of people still coming into the room, so we will get started maybe at 10:02. Hopefully that's okay. Give everyone ample time to jump on the line. And again, for those of you just jumping on, we're going to wait till about one more minute. Still showing a lot of people signing in as we speak, so we're going to make sure as many folks can get on before we start, but I promise we'll have you out here in an hour. All right, everybody, 10:02. I want to thank everybody. Good morning, first off, and thank everybody for attending the Thiessen, Wickert, and Lair's Med Pay and PIP Subrogation 101 presentation. My name is Mark Solomon. I am the managing partner of the firm's Austin, Texas office. I've been in practice, I guess now 16 years, handling subrogation of all kinds across the country, mainly focused on Texas, but I'm also licensed in Colorado and Georgia as well. I attended the University of Texas for undergrad and went to South Texas College of Law in Houston. I've got one daughter, 6, who's starting first grade tomorrow, so it should be an exciting day. But again, I want to thank everybody for attending this presentation. We hope you'll get something out of it. I'm going to go through just a few housekeeping issues here. This is what you should see, and getting to sign on to the webinar. There should be a phone access code, or hopefully you're hearing me through your computer speaker just fine. There's going to be, we're over 300 attendees right now and expecting more. Usually on smaller ones, I would open it up and allow folks to ask questions, but with this many people, I would ask that everybody just ask any questions you may have in the questions tab on your dashboard. You can see it here. It's got a question, we can do that. I am going to wait until the end to answer questions. I will get to as many as I can within our allotted 1 hour time. If by chance I do not get to your question, we will have those recorded, and I will reach back out via email to try to get every question answered as best I can. So, assuming everyone's on and ready to go, we've still got some people signing in, but we're going to get started. So again, this is Med Pay and PIP Subrogation 101. This is an overview. It's more Texas focused, but we've got a whole lot of examples from jurisdictions across the country on Med Pay and PIP Subro. and how that works, in your day-to-day dealings for anybody that handles subrogation claims. So, little introduction. So we always want to say effective auto subrogation is critical because there's so many factors here that we're dealing with. Right now, current estimate, there are 275 million cars in the United States. It's the most of any country in the world. Each year, we have over 7 million automobile accidents. And the actual financial toll on this is staggering. It's $300 billion when all is said and done. When you factor in property damage and injuries, it's a massive, massive amount of money that deals with automobile accidents. So 3 million people are injured every single year in the United States in automobile accidents. We have roughly 45,000 people killed. That averages out to about 115 people per day. And if you do the timing and the average, within this hour, 10 people will perish in automobile accidents during this webinar. So it's pretty sobering to think of how just frequent auto accidents and what kind of toll they take on us on a day-to-day basis. There are $70 billion in annual passenger auto liability claims that are paid out, and $40 billion in annual passenger auto collision claims that are paid out. So we're looking at that 40 billion as basically subrogation. Obviously not all 40 billion, but a good portion of that may occur because of a third-party tortfeasor. And that's money that we can recover as insurance subrogation. So we're going to take a look first at just an overview of some coverages, what we can expect before we get in kind of the nuts and bolts of the subro aspects. So personal automobile coverage, everyone's required to have this, right? You've got your liability, which covers bodily injury and property. The numbers here are for Texas, the 30, 60, 25. So 30 for liability for injury per person, with a net total of 60 per accident, and then the 25 is the property damage that you see for liability against other drivers. Anybody that's been doing this knows the 25 likely isn't enough money, given how expensive car components are and how everything kind of breaks a lot more. All the plastic and backup cameras and everything that goes into a car, 25,000 in minimum liability doesn't get you very far on property damage. So my unsolicited advice is up your liability limits as high as you can go, which you can afford them. It's going to save you some trouble if you're ever in an accident in the future, especially folks with states like California with only 5K in minimum limits, 10K in other places. It just doesn't pay out. But in addition to your personal automobile coverage on liability, you've got Med Pay coverage. You've got personal injury protection, which is PIP, which I'll refer to a bunch today. And then you have the option, some it's required, but uninsured and underinsured motorist coverage. And then, of course, you've got your collision and comprehensive, which deals with reasonable repairs to your vehicle. Sometimes it's an actual cash value, and sometimes it's a replacement value. You can actually buy a policy that has either or. So if you wreck your 10-year-old car with an RCV policy, you can get a brand new car in theory. All right, additional coverage that we see, these are on the commercial aspect. We have hired and non-owned coverage. That's generally for trucking, driving and other vehicle coverage. That's more in a commercial sense. And then we've got a garage liability coverage, which your auto dealers, repair shops is kind of a general liability policy. And then a garage keeper's liability coverage, which covers vehicles that are either in for repair or customers' vehicles, or test drives, whatever it may be. But usually the garage keepers and garage liability, two separate. So to make sure everyone's with us this morning, we've got a few polling questions we need everyone to answer. So polling question number 1, what is the annual financial toll of auto wrecks in the United States? I'll give you guys a minute to answer this one. Is it A, 100 million, B, 1 billion, C, 100 billion, or D, 300 billion? All right, 88% of you have voted so far. 42% of those that voted got the correct answer. It is D, $300 billion annual financial toll of auto wrecks in the United States. So, quite a serious amount of money that has an economic impact on folks here in the United States. So, moving on, let's look at no-fault insurance. Typically, it comes in the form of personal injury protection or PIP, and we'll discuss all of these as we get down. This is just a quick overview. Some states have thresholds where you can subrogate. Some have a limited tort. Some go with what's called a loss transfer. Some states have a modified no fault. Some states have what's called an add-on no fault. Other states, of course, have voluntary choice no fault. And then we'll discuss a bit about the future of no fault. So as you can see, with this no fault, kind of a brave new world, there are a lot of different moving parts when we deal with this, but hopefully we'll clarify that as much as we can today, and then hopefully get a better understanding of where we're headed with this no fault. Okay. So when we look at subrogating medical and property claims, so we've got some different methods and legal bases for how we go about subrogating these auto claims. So generally the rights start with contractual, which we call conventional subrogation. And that will be in your policy language of your actual insuring agreement. We've got a sample of that coming up. And then there's subrogation agreements. There's something called equitable or legal subrogation, which basically stands for the principle that if you pay for the debt of another, you get to stand in the shoes. So it's subrogation, but on a common law legal basis. When we're looking at this, and we'll discuss all these again as we get further in the presentation, we've got the made whole doctrine. We've got the common fund doctrine we need to deal with. And then there's statutory subrogation and reimbursement. A lot of times this deals with PIP and Med Pay. It's very strong on the workers' compensation side of things. And we will deal with a lot of work comp in these auto wrecks. There are a lot of folks who are injured while driving within the course and scope of their employment. Just think of how many car wrecks there are in a day, as we touched on earlier. And as long as those are usually within working hours, work comp's going to get involved a lot. And then we'll deal with Medicare and Medicaid. So contractual subrogation, policy language that you're typically going to see in a standard automobile insurance policy. So you're going to have one that says, example A, if we, it means the insurer, make a payment under this policy and the person to or for whom payment was made has a right to recover damages from another, we shall be subrogated to that right. So that basically means if there's a third-party tortfeasor who might be responsible for your damages and we paid out, we are subrogated to that. And example B, we see a lot. If we make a payment under this policy and the person to or for whom payment is made recovers damages from another, that person shall, this is a requirement under the contract, one, hold in trust for us the proceeds of the recovery, and two, reimburse us to the extent of the recovery. That is our typical contractual subrogation language that we see. Moving on to the second aspect we talked about, the statutory subrogation. This comes from the Texas Civil Practice and Remedies Code, section 140.004, which says contractual subrogation rights author. So an issuer of a plan that provides benefits described in section 140.002, and I will have you believe me that that is for insurance, under which the policy or plan issuer may be obligated to make payments or provide medical or surgical benefits to or on behalf of a covered individual as a result of a personal injury to the individual caused by the tortious conduct of a, here's the key, third party, may contract to be subrogated to and have a right of reimbursement for payments made or costs of benefits provided from the individual's recovery for that injury, subject to that chapter. So it is a very long way of saying If a third party causes a tort and they're responsible, you can contractually require subrogation in your insuring agreement. Thankfully, the legislator made sure to make that as long as possible and as complicated as possible for saying something that could have been done in half the words. That's just my opinion. So we're looking at our subrogation, right? We're attorneys and we're professionals working in the subrogation subrogation world, excuse me. How do we go about this? So we want to try to settle with the third party as soon as possible. We don't want to let the case go stale, and by stale we mean maybe your insured files an injury claim and settles the case quickly without us paying proper attention to it. When we settle, we want to take a look at made whole issues. Those vary by every single state. A lot of times, if we've only got the property claim, we'll wait on the BI claims, but that also applies for the Med Pay and PIP. It's always key to work with your insureds and let them know that if they've got injuries outside of the Med Pay and PIP that we're dealing with, you want to work with them, because actually a happy customer is going to be a consistent customer as well. And we want to look at offer of settlement statutes. That's where the attorneys, both on the plaintiff and defense, will get involved in terms of trying to get a prompt settlement. What these statutes typically are is that if you make an offer of settlement, a certain percentage threshold is either met or not met at trial, it may shift all the fees back to the party who did not accept the settlement within that certain percentage threshold. Other options, right? We've all dealt with, I'm sure, intercompany arbitration. That's very efficient in getting claims taken care of. Very easy practice and much quicker than going through the legal practice. Obviously, there are a lot of companies who are signatory to ARB forums, so that is a very good resource to use. We've also got the option of filing a subrogation suit. When we're doing this, we need to look at the fees that we're going to incur, costs such as suit and service, maybe depositions, possibly an expert, and then obviously the cost effectiveness of doing all. We're going to need to establish liability, but at what cost? Obviously, you don't want to spend, $3,000 on a case that's only worth $2,500. That's not going to make good economic sense. And then we look at possibly an intervention. If your insured has filed suit, as the PIP and Med Pay provider, do we want to get involved in that? Certain states it's mandatory, certain states it's discretionary, and certain states it's outright prohibited for the carrier to be involved in this. The intervention, mandatory, discretionary, prohibited, we see that a lot more in the work comp realm of things. For example, certain states, you just put folks on notice of lien and you can't get into the case at all. In New Mexico, whereas Texas is very friendly for work comp, and we can intervene and even run the show on these types of damages. So that's something that can be looked at on a state-by-state basis. And then obviously, notice of liens. We talk about notice all the time in the subro world, putting all the parties on notice of the lien or any subrogation issue that you have. This is our last resort, right? And it's only if necessary sensible to do so. If all of the other options above aren't there, place everybody on notice. But as a good rule of thumb, do that anyway. Communicate with your insured, communicate with the other side, and communicate with your insured's counsel if they have it, and let them know you're involved. Let them know you've got your lien, what you're looking for in terms of your subrogation recovery. So we're looking at Med Pay and PIP subrogation today. So let's dig into this deeper. Medical payment, we'll call Med Pay coverage. So what it does, it pays for medical expenses to insureds and passengers in an auto accident or as pedestrians, regardless of fault. And that usually includes coverage while your insured is driving or riding in somebody else's vehicle. Usually arises out of the use of a motor vehicle, and that can be very broadly defined. Our personal injury protection PIP coverage, it will pay first-party medical expenses, lost wages, and funeral benefits for an insured and the passengers. There's a list of states where PIP is actually required. So that's Arkansas, Delaware, Florida, Hawaii, Kansas, Kentucky, Maryland, Massachusetts, Michigan, Minnesota, New Jersey, New York, North Dakota, Oregon, Pennsylvania, and Utah. So a lot of times people think PIP, it's often associated with no fault insurance because it pays regardless of fault. That is the key to PIP, is that it's kind of a bridge to get you over any gap to pay for these first party expenses and wages, possibly funeral benefits. Some states will provide for med pay benefits, but not PIP, and vice versa. Beauty of living in all 50 states here in the United States is that every single one is unique in its own, and we deal with that on a daily basis. So look at our no-fault auto insurance. So this will pay first-party expenses and lost wages to both insureds and passengers without regard to fault. And what we do with this is in exchange for an insured or passenger limiting their right to sue the tortfeasor for certain types of damages. So a lot of these states will have a threshold that you cannot sue for these benefits until a certain dollar amount has been reached. And the theory behind this is that it keeps costs down because people are just getting paid. You know, if you've got a minor accident with just a few cuts and bruises, there's not going to be a lawsuit stemming from it. Your PIP is going to pay this, and no one's going to seek reimbursement. It's just kind of almost a cost of doing business, if you will. You submit your benefits, you get paid, and you move along, and that's it. No state is absolute no fault, right? No one gives up the right to sue completely. They can do these thresholds, but I believe there'd be quite the constitutional issue if someone passed a law limiting you from filing suit. I don't think the founders who wrote the Constitution would be too happy with that, and the Supreme Court would likely agree. So auto insurance generally falls into 4 categories. We've got a traditional tort system, right? There's no PIP and no restrictions on suit. We've got an add-on state category, which optional PIP paid. Again, no restrictions on suing. These 9 states are Arkansas, Delaware, Maryland, Oregon, South Carolina, South Dakota, Texas, Virginia, and Washington. We've got modified no fault. First party benefits are paid without regard to fault. But again, we just talked about that monetary or verbal threshold to sue. 12 states have this, where a verbal threshold must be met. And then we've got additional states that have the monetary threshold. These are kind of a mix of both. And then we've got choice no fault, the choice of pure no fault. So there's no suit for non-economic damages, or modified no fault. You can sue the modified driver. So 3 states follow this: New Jersey, Pennsylvania, and Kentucky. So New Jersey can be confusing at times. You know, a bunch of losses out there, and it's its own little beast, but we can walk you through that if you ever run into issues. So Med Pay Subrogation is heavily applicable to state law. The state law that determines whether or not Med Pay Subrogation and reimbursement are allowed. So the majority of states, 29 of them, allow for Med Pay Subrogation and or reimbursement. California is a state that only allows for reimbursement, not subrogation, just reimbursement. So you place people on notice and then get reimbursement back either from the tortfeasor or the carrier. Some require several language in the policy. Alabama, Illinois, and Louisiana require that the Med Pay Subrogation language be written into the policy in order for it to occur. Some outright prohibit subrogation at all. So Arizona only allows for perfection of a lien, no subrogation. Some states allow subrogation only if a statute authorizes. So in Connecticut, they've got a unique statute that authorizes Med Pay Subrogation. And then District of Columbia will prohibit payment of any Med Pay benefits. And then some prohibit it altogether. So in Colorado, where I'm licensed, there is no such thing as Med Pay Subrogation. They did away with that a few years back. Jury's still out on whether that's been beneficial. So no fault PIP subrogation, we're looking at no fault states. So there's a lien, a reimbursement right, and a credit in Arkansas. We've got a reimbursement right against a third party carrier only in Delaware. You can't go after the subrogation, or excuse me, the tortfeasor and subro, you can only get reimbursement from the carrier. It's, on all intents and purposes, the same thing. It's just kind of two different ways to call the same thing, you know, potato, potato on this one. Reimbursement if one non-passenger vehicle, that's in the District of Columbia, and then Iowa, for example, has no limitation. So, you know, the key to all this and giving you all the examples is to really drive home the point that there are, you know, every jurisdiction approaches things in a different way. And knowing how to approach them is going to be the key in being successful and being able to recover either in PIP and or Med Pay when these are made. So we're looking at no fault states. So again, there's a lien reimbursement right and credit in Arkansas. Can we pursue, right? And so in Florida, if a commercial vehicle is involved or the third party is uninsured, you can get your PIP reimbursement. Most states will have a definition of what a commercial vehicle is. Sometimes it's a certain weight, sometimes it's how many passengers it'll cover. But a lot of states you'll see as well, PIP subrogation. For example, in Texas is the same. There's no PIP subrogation unless the tortfeasor is uninsured. If anybody here has ever handled uninsured motorist work, you know what a uphill battle that can be in trying to recover. I think the last stat I've read is that the recovery rate on uninsured motorist claims, either property damage or this PIP, is hovering around 7 cents on the dollar. So it is very tough to recover, especially in states where there's not a whole lot of recourse against the debtor who caused the loss. So again, we mentioned in DC, it's reimbursement of PIP if one is a non-passenger vehicle. So that could be a commercial truck. After 18 months in Kansas and a $2,000 threshold is met, you can go after your PIP subrogation. Again, Kentucky follows the uninsured, but if they are insured, it's a benefit. I forget what the BRB is, benefit review something. I'm sorry, I don't have it off the top of my head. From the third party carrier, it's basically a nice southern way of saying subrogation. If I forget what it actually is in Kentucky. Massachusetts, you can recover from a third party carrier. If a subro suit is filed, you can actually recover more. Seems a little backwards, but that is what they choose in Massachusetts. In Michigan, if you're parked, it's a building or an out-of-state accident or a third party is uninsured, your PIP recovery can occur. And then New Jersey, reimbursement if a third party not required to have PIP or commercial or is a commercial vehicle. New Jersey is always interesting because New Jersey PIP minimum limits are $250,000. Very, very high. And so what you see a lot is folks from Delaware and Pennsylvania who are in and out of New Jersey as well as New York. When they cross over into New Jersey, their PIP benefits all go up to that automatic $250,000. Just like if you had a minimum limits policy in Arizona and drove to Texas, your limits would increase once you cross that state line, of course, going through New Mexico first. And then in New York, intercompany arbitration can happen for PIP if one vehicle is over 6,500 pounds that's involved. And that's the New York definition, I think, of what is a commercial vehicle. One that is over 60. We touched on earlier the made whole doctrine. So the made whole doctrine basically says where there is a limited pool, third-party dollars for which the subrogated carrier and the insured must compete, the carrier cannot subrogate against or participate in those funds until the insured has been made whole. So what this means in practical purposes is that your insured needs to be paid back every single penny that they spent out in terms of compensating them for their injuries. A lot of times this made whole doctrine will also apply to their deductible. So until your insured has recovered all of their money, out-of-pocket expenses, and been reimbursed, there is no subrogation. course, every state applies this differently as well, so we'll go through that. What is the legal authority for the doctrine? Excuse me, in Colorado, the doctrine is codified. It's the same as in Georgia as well. In Georgia, it permits subrogation only where the insured's recovery exceeds the sum of all categories of damages. The key there being all categories of damages. So your non-economic damages such as pain and suffering, that counts as well. So the recovery needs to exceed every bit of damages that's out there before the carriers can go ahead and start their subrogation. A lot of times we can be involved from the get-go, but claims will close based on a made whole argument. Anybody that's ever dealt with a personal injury attorney will know that most of these injury attorneys are going to be well versed in this made whole argument. We're going to talk in a little bit about how that can be avoided. There's some statutory case law that touches on that as well. In Wisconsin, there's case law, out of the common law as we call it, that established the made whole doctrine in 1982. And of course, we weren't split enough at the state level. The federal courts are also split. So the 6th, the 9th, and the 11th judicial districts, that is their default rule. Of course, they've got an exception, which is it applies unless there's an express provision to the contrary. So you can contract around the made whole doctrine. And then the 1st, 5th, and 8th districts, they reject the federal made whole as a default. The rest of the districts, as of today, we don't know whether they've adopted it as not common. So, as we talked about, can the made whole doctrine be negated by policy terms? These states here, Alabama, California, Connecticut, the District of Columbia, Florida, Hawaii, Illinois, Indiana, Iowa, Kansas, Kentucky, Maryland, Massachusetts, Minnesota, Nebraska, New Jersey, Ohio, Oklahoma, South Dakota, Utah, Virginia, Washington, and West Virginia all allow contract language to override the made whole doctrine. So as you can see, there's a majority of states who don't believe in the made whole doctrine. They are more insurance friendly and believe that the insurance company should also be paid back as well and be allowed to participate. In many cases, a very simple subrogation provision is sufficient to accomplish the getting around of the made whole doctrine. So it doesn't take a whole lot. We are up to, excuse me, polling question number 2. The made whole doctrine can be negated by policy terms. Is it A, true, or B, false? All right. Well, I'm going to go ahead and let you in. This is a trick question because there's not really a wrong answer, right? It depends is the answer. It is true. It can be negated by policy terms, and it is also false because certain states will not allow you to contract around that. So that was a freebie for everyone. There is no wrong answer. But generally, it's true. The majority of states hold that. But again, certain states are very strong on their made whole. You're not allowed to get it. Looking at, as we touched on earlier, there are ways to defeat the made whole doctrine. And the certain ways to defeat these are here in case laws. So in Indiana in 2011, they had the holding that some courts held that any settlement and release of all claims presumptively makes the insured whole. So if you settle and you release all the claims, Indiana courts have said that's a made whole presumption. Now, that is a rebuttable presumption. What is meant by that is that It can be challenged in court. So if you're in Indiana and you're subrogating and you say, well, Mr. or Ms. Insured, you signed off on a release, you've been made whole. They can go to the court and say, well, we signed off on a release for a minimum policy limits. We were very seriously injured. That's not going to really count. So that can change the made whole doctrine. There are other courts, for example, we deal with this a lot in Oregon, where there's a presumption that if you settle for under the policy limits, the made whole doctrine can be waived. We've had very good success fighting that fight in terms of, just say there's a $50,000 limit and the insured settles for 30, and then they go try to make a made whole argument. Well, if they've taken less than the policy limits, there's a presumption that they've been made whole. Otherwise, they would have taken more than the limits or gone to court and been awarded more than that by a judge or jury. So here we've talked about that. Other courts require the settlement must be within the tortfeasor's policy limits in order to be presumptive. Oregon I mentioned, but this is also West Virginia, Ohio, and Georgia as well. And then, as you see in Colorado, that last statute there, 10-1-135, creates a rebuttable presumption that we discussed earlier. In Florida, for example, a jury verdict constitutes a full recovery for purposes of the made whole doctrine. So if your client, your insured, takes the case all the way and receives a jury verdict, that's made whole in Florida. That also occurs in Nebraska, Washington, and Texas as well. And so once you get the verdict, you can still continue to pursue and be reimbursed, obviously depending on your state law allowing for that, for your PIP and or Med Pay. So we're looking at what happens with contributory negligence as it applies to made whole. So the additional question is whether an insured's contributory negligence is relevant in determining the loss for which the insured is entitled to be, quote, made whole. So a court must determine, right, the trier of fact needs to determine whether the insured is made whole for purposes of subrogation when it receives all of the damages that it seeks, or whether the insured is made whole when it receives all the damages which it is legally entitled to recover. So the example we have here comes out of Wisconsin. So the plaintiff here had $100,000 in medical expenses, but was 50% at fault. So applying everything to this case, the health insurer may enforce its subrogation rights over the amount that is in dispute. So that's 50,000 because that's 50% of 100. As noted above, the plaintiff sustained 100 in medical expenses as a result of the accident, but because they were 50% at fault for the accident and the ensuing damages to themselves, they are only entitled to recover, the carrier, 50% of the damages, again, 50,000. Excuse me. Following the accident, all right, the health insurer did pay the full amount under the contract, under their policy of 100 grand. This amount exceeds the amount the plaintiff is legally entitled to recover, which was 50. So accordingly, the health insurer, may enforce the subrogation rights and recover the amount of medical expenses that the plaintiff could have recovered. So this amounts to $50,000. So basically, you are standing in the shoes of your insured when it comes to this, and you are only entitled to recover what your insured can. So again, they're 50% at fault. You as the insurer are only entitled to recover 50% of what you paid out. So what is the common fund doctrine? Anybody that's ever dealt with an injury counsel is going to know what this is. So the common fund doctrine is defined as a litigant who creates, discovers, increases, or preserves a fund to which others also have a claim is entitled to recover litigation costs and attorney's fees from that fund. That doctrine is an equitable doctrine designed to prevent unjust enrichment. So basically, if you're going to get this argument, insured's attorney is going to say, I created this common fund. I I made it rain all this money that we're all here to recover. And as such, I'm entitled to my costs and fees from that fund. That is correct. But of course, there are ways to get around the common fund. So it is applied differently from state to state. Right? You need to determine, does the made-whole doctrine apply? What is the proportion of attorney's fees or costs that are owed? We need to look at what if the carrier assists in effectuating recovery. So if we as the carrier bring our own suit, we intervene, we make our own demand, we provide records, we provide bills, we make liability arguments, we hire an expert. That's all assisting in affecting the recovery. We need to look at, can the common fund doctrine be avoided? Must notice be given to a carrier or plaintiff's counsel? Either vice versa, the plaintiff's counsel notice to the carrier and the carrier to the plaintiff's counsel. Must the insured be made whole for the same damage elements? So we're looking at a property loss versus a bodily injury claim. We're looking at economic versus non-economic damage, your bills versus your pain and suffering. And then our attorney's fees included in this calculation. All this factors in to how the common fund doctrine is calculated. So does the common fund doctrine apply? Here's some examples. In Arkansas, yes, it's by statute. Arkansas says that a carrier must contribute in proportion it benefits from recovery. So it's basically a pro rata proportion on how much they recover on their subrogation aspect is what they must contribute to the injury counsel. Connecticut, they don't talk about it at all. It has not been discussed in Connecticut law whether the common fund doctrine applies. So it's kind of a brave new world up there. Indiana allows for common fund doctrine fees in personal injury cases, but they are silent as to whether that counts on property damage claims. Iowa requires a pro rata contribution. Massachusetts has not applied this to automobile subrogation. Mississippi hasn't done it either. In North Dakota, the doctrine's never even been adopted. You can see it ranges from state to state as to whether the common fund argument is going to fly. Hawaii, two different methods are applied. One's called the lodestar approach. I could teach a whole nother class on that. It's very confusing. The other one's a percentage method. Maine gives it the court discretion. But they have a statutory provision that requires a pro rata share in Med Pay Subro. The state of Maryland divides the total recovery into total attorney's fees and multiply by the total subrogation interest. So they have their own kind of pro rata calculation. Minnesota, there's no hard rule. They kind of just say, well, we'll do it on a case-by-case basis. But generally, we hold between 20 and 30%. So I did have this once in Minnesota, and it was very interesting to learn how they did it. They just kind of wing it, for lack of a better term. So looking at the common fund doctrine and can it be avoided? In Arkansas, yes, if a carrier negotiates and tries to sell directly. So we send out our demand in Arkansas. We try to get something done with the tortfeasor and or the carrier. That avoids the common fund doctrine. Florida, the rule is if the carrier provides substantial assistance to the insured. That's not really been defined, but it's something you just need to put enough work in and make the argument that we were substantially assisted in recovery. Illinois, yes, if the insurer participates in the creation of the fund, no attorney's fees from an unwilling recipient is what Illinois says. Maryland, common fund can be completely avoided if the carrier intervenes and is represented. So once they get involved in the suit, you can avoid all common fund doctrine fees in Maryland. Texas, it's if the carrier participates or assists. A lot of times that requires being intervened, showing up to depots, making your own demand, and doing everything you can to protect your client's interests. And we'll touch on this in a little bit, but you got to understand that the job of your insured's injury counsel is to keep as much money out of the carrier's pocket and into their own and their client's pocket as possible. So active participation by subrogation counsel is the most common way to avoid the common fund. So Utah and Tennessee say yes, common fund only applies to passive beneficiaries. So if you're active in a case in Utah and Tennessee, you can recover. Common fund doctrine about notice, right? For example, in Idaho, if there's no notice, no attorney's fees or costs may be deducted from reimbursement. So the carrier must be given proper notice here by their insured attorney. Notice is important in Louisiana. It's a prerequisite for the application of the common fund doctrine. Louisiana, it's called Moody fees. Tennessee, notice must be given. Tennessee will actually say, I love the irony in this, an insured's attorney can be considered a volunteer. Obviously, the volunteer state, but Tennessee says if there's no notice given, that the attorney is actually volunteering their services on behalf of the carrier. Vermont trial court must be consulted to see if the common fund doctrine is equitable based on the facts of the particular case. So that's a case-by-case basis in Vermont that they will look at as well. So active participation defense, defeating the doctrine by retaining subrogation counts. So an intervention can, in some cases, defeat the application. There's a case out of Wisconsin that says a subrogated insurer who participated in the action and was represented by its own counsel defeated the common fund doctrine. There is even authority that activity before litigation can destroy the doctrine. So there's a case out of Texas wherein Allstate notified the tortfeasor of the claim, made a demand stating that it was pursuing the subrogation claim independently, asked the tortfeasor to issue a separate check to Allstate as the sole payee, let the insured's attorney know, hey, please do not take any action to collect Allstate's claim, and then submitted all the bills to support the subrogation. In this case, said that, yeah, that defeated the common fund doctrine. Because as you see here, this was just a general claims handling procedure that the carrier undertook to effectuate their own settlement in subrogation. So if you're active in pursuing your own case, whether that be by subrogation counsel or by yourself, you can save a whole lot of fees going to someone else who you never hired. Alabama says the doctrine will not apply, where the plaintiff's attorney outright tries to defeat the lien. So if the plaintiff's attorney is trying to get rid of it, it's not going to apply. So some quick tips for avoiding the common fund doctrine. We want to send our demand for subrogation as soon as possible. We want to try to negotiate that claim and or assign it. Get subrogation counsel involved. A lot of times subrogation counsel can do this hourly to keep costs down, just to get out a demand and notice letter. Demand proof of the plaintiff's counsel's time. Want to know how much time they put into a file. They send a demand and get paid and say we're entitled to 40%. If they've only put a half hour into the file, the court's probably not going to. Keep good records of the plaintiff's counsel effort to destroy your lien, whatever argument they may be making. And then demonstrate a need for protection of lien by your own counsel. So make sure that counsel is involved. And then if a plaintiff's attorney represents you, you got to waive the fees if they try to defend your interests. And then know that there's an inherent conflict, as we just talked about. They, again, are not representing you, the company. They are representing your insured and trying to keep every dollar out of the company's hands. All right, polling question number 3, final one. The common fund doctrine can be defeated via the use of subrogation counsel, true or false? All right, we've got most people have voted, 81% true. That is the correct answer. So yes, the common fund doctrine can be defeated via the use of subrogation counsel and active participation in claims. So moving on, we had actually a question pop up. I see Kim Eastern had talked about diversity of states, such as a policy state in Missouri, and venue, Illinois, can subrogation occur. So we're going to go through this, Kim. Hopefully address this question. So interstate subrogation conflict of laws. So the U.S. Constitution deals with this, but the reason conflict of laws is important in subrogation because it determines whether or not you can recover. It also makes it difficult. We will touch on these in some further examples, but wouldn't be a presentation without some Latin in here. So we follow the conflict of law rule of the forum state. It's called lex loci delicti. It means the law of the place where the delict, tort, is committed. We also look at the most significant contacts, the government interest, and the contract policy choice of law provision. You may have something that says anything litigated this has to be litigated pursuant to the laws of the state of Kansas. You just see that. So the way we want to do that is we want to figure out how to turn conflict of laws into an advantage for us. So the procedure we look at is we determine all of the variables in effect. We want to determine which subrogation laws are going to apply in both states. And we want to figure out, is there a conflict? The conflict is defined as whether there is a difference in laws that results in two different outcomes. And what we're going to look at is some states may allow for a PIP Med Pay Subro and some may not. Their citizens are involved in accidents across state lines. How do we resolve that? So generally, if there's a conflict, we apply the conflict rule of the state where the suit was filed. Here's an example. A New Jersey driver who has the no fault is involved in an accident in Texas, or a Texas driver involved in an accident in New Jersey with that no fault. Your coverage switches to match the minimums required by each state. Another example is Wisconsin driver. Wisconsin allows Med Pay Subro is involved in an accident in California where there is no Med Pay Subro. We've got some concrete examples we'll go through in a minute. So the traditional conflict of law rules are the lex loci delicti, as we said, and restatement, which is kind of an overview by legal scholars of what they think is the best way for things to be interpreted. It's very strong. It's very well thought out. And then we've got the most significant contact. So state insurance statutes, New Jersey, an out-of-state vehicle is deemed to provide new Jersey coverage if the carrier is authorized to do business. New York State, their out-of-state drivers may be deemed covered persons. You may be able to subrogate them. Law of the wrong here applies of the forum state where the accident occurred. It's the minority rule in 12 states. We've got the Larson rule, which came from the restatement. It's the legal analysis. Applies the law of the enabling states where the benefits were paid. And then most significant contacts is the majority rule. It applies the law of the state with the most significant relationship to the incident. It's kind of expands on number one here, but it just kind of restates it in a way that dials it in a little bit. So here's our hypothetical example. We've got an accident in Florida and PIP paid under Kansas law for a Kansas policy. So Florida law determines which state's laws govern subrogation. So Florida says there's no PIP subro unless a commercial vehicle is involved. The Florida conflict law says lex loci contractus. So they apply the law of the state where the policy is issued. Kansas law applies. So Florida law will allow that Kansas law. Kansas allows PIP subrogation and reimbursement. So to the extent PIP benefits duplicated in the tort case, once we reach a $2,000 threshold, less any common fund and contributory negligence, we can recover for this accident in Florida with our Kansas contract. Another example we have here, an accident in Missouri, and PIP was paid under Kansas law, but an Illinois tortfeasor. We've got 3 different states involved here. The Missouri law determines which state's laws will govern subrogation. Missouri says there's no PIP subrogation because it's against public policy. Kansas, of course, says, hey, PIP subrogation is allowed. The Missouri conflict law says it's the most significant relationship test. So they look at the governmental interest. And Missouri actually says we've got a significant interest in the non-assignability of injury. So Missouri says Missouri law is going to apply. There's no subrogation or reimbursement for the PIP paid under Kansas law for the accident in Missouri. obviously contrasted to our example we had earlier where this accident happened in Florida, the PIP reimbursement would be allowed. So one thing we need to be on notice of, right? If a third party and its insurer settle with our insured directly, here, and we talked about notice, if the other carrier has knowledge of the subrogation claim, we can pursue the subrogation claim against that carrier. If they don't have knowledge, we are barred. So that is an important aspect of making sure that you've got notice put out. Had a colleague that most people have seen this. You'll go try to subrogate, and they've settled with your insured, and they settle. Your insured signs an indemnity waiver, indemnification agreement. This person was able to sue the other party because they were put on notice before the release was signed for tortious interference with contract and won and got a major award against a carrier who tried to settle around and essentially make his own client sue their own insured through that indemnity agreement because they had notice of the subro claim before they did that. That was allowed. So long story short, put everybody on notice as quickly as you can. What constitutes proper notice will vary, but even now with email and most people having a good fax or a main claims number to send in, as long as you can prove that was received or sent in, that's usually going to be okay. New Jersey and North Dakota say that a statutory right of PIP subro can't be waived. Some states have specific notice letter requirements. Ohio's got one. And then pursuit of reimbursement rights are always still available. That may fall under. So in an hour, I'm going to try to get to a few questions. We started about 10:02. I'm showing 10:57, so I'm going to try to see what we can. But we've got a book that we publish, Automobile Insurance Subrogation in all 50 states. This is a very thick, very heavy book, but it is a unbelievably comprehensive overview of subrogating automobile insurance claims across the country. We keep this updated as much as possible. And again, if you're on this webinar, I would be willing to bet the house that you've been on our website at some point to get information. And again, we pride ourselves on keeping that updated almost daily, if not daily, with any new laws that come out, any new developments, any new cases, to try to provide to you, our clients, the best and most updated resource we can in terms of helping to maximize your recovery across the country. So, as I said, I'm going to scroll through a couple of questions here. If I don't get to your question and it's written in the question box, it will get printed out and sent to me later, and I will do the best I can to answer all of those today. If not, I will get to you tomorrow. So let's see what we've got. We've only got a couple of minutes. I'm sorry, there's just a lot more here than I thought. Shannon Keel writes, would also like to see where ERISA prevailed in these applications or not of these doctrines. Shannon, ERISA is its own unique situation. ERISA is federally preempt state law. So ERISA laws will trump any state law. So if you pay something under an ERISA provision, basically you're going to have the strongest hand at the table. The ERISA preemption on subrogation is all mandated by federal law and the ERISA contract. So once you get the ERISA involved, that's going to trump any state. Hopefully that helps out. OCAC policies, Keisha Walker writes, for occupational accident policies, the policy paid in med disability payments to the insured. The insured makes a claim against their own personal UIM or PIP policy. What gives the OCAC insurer the right to subrogate the insured's personal auto UM, or PIP coverage? How does the insured's UM? So OCAC is kind of this unique area. A lot of states, Texas especially, has its own unique OCAC reimbursement provisions. Generally, the OCAC is going to be looked at in the same realm of a work comp carrier. And so the same state laws are going to apply generally to the OCAC policy as they would if it was just a normal work comp policy. So I am showing we are out of time again. I want to thank everybody for attending. I want to encourage you all to use our website. If you've got any questions, you can email us. We've got an Ask a Question feature on the website as well. You can pick up the phone and give us a call. I really want to thank everybody for taking time out of their busy day for attending this. We hope it was beneficial. We hope it's helpful, and we hope we will see you in future webinars down the road. Thank you, everybody. Have a great day.